Hello everyone, I am Neha Nigam, Assistant Professor in IIMT College of Management from BBA Department. Today I am going to discuss my topic Indian Contract Act 1872. So let's get started. When we are talking about Indian Contract Act, first we know what is the meaning of contract. A contract is an agreement between two people that creates a legal obligation to perform, as we say, according to section 2, subsection H, a contract is defined as an agreement which is enforceable before the law. Now, what is agreement? According to section 2, subsection E, every promise or set of promise forming consideration for each other. What is promise? According to section 2, subsection B, when a person made a proposal to another, to whom proposal is made is to whom proposal is made if proposal is uncertain thereto. For example, if one person is plumber and the other one is electrician, they might agree to complete certain work for each other as a trade exchange. That is the general meaning of contract. Now, what is meaning of offer? According to section 2, subsection A, when a person made a proposal, when he signifies to another his willingness to do or to abstain from doing something, like agreement is equal to offer plus acceptance. What is consensus? According to section 13, as we say, meeting of minds or identity of minds or receiving the same thing in same sense at the same time. That is called consensus. Here, as can we say, as we say, agreement plus legal obligation is called contract. So all agreement are contract, but all contract are not agreement. There is contract is equal to agreement plus enforceability before the law is called contract. Here, essential elements of valid contract according to section 10. Let's get discussed. First one is offer and acceptance. Other one is intention to create legal relationship. Other one is consensus, consideration, capacity to contract, free consent. Other is legality of object. Other is possibility of performance and writing and registration. They all are the essential elements of valid contract. Now, there is a types of contract. First one is valid contract. It includes absolute contract, contingent contract according to section 31 to 36, express contract, employed, implied and quasi contract, section 68 to 72. Now, what is valid contract? Let's get discussed one by one. Valid contract is if all the conditions are fulfilled, it is called as a valid contract. In a contract to do or not to do something, if an event is collateral, does or does not happen is contingent contract. Express contract is when contract are either in writing or in oral. When contract are neither in writing nor in oral is called implied contract. A contract which is not dependent on fulfillment of any condition is called absolute contract. So when we are talking about valid contract, there are in some invalid contracts. Invalid contracts are void contracts, voidable contracts, illegal contracts, and enforceable contract. So, what is invalid contract? In a contract, if any one condition is not fulfilled, is void contract. When an agreement which is not valid from the beginning, an agreement which is valid in the beginning, but due to some supervening impossibility, the contract becomes void. So, voidable contract is when a contract which is valid unless until avoided by the party. Illegal contract, an agreement forbidden by law. That is called illegal contract. It is valid, but due to some technical defect, the contract becomes void. In case defects are removed, the contract is enforceable. That is enforceable contract, like lack of registration, lack of signature, etc. So there, here are some other types of contracts. Executed contracts. Other one is executory contract. Other one is the unilateral contract, and the last bilateral contract. So, what is the meaning of executed contract? When in a contract where both the parties have performed their obligation, there is remaining nothing to perform. In a contract where both the parties are yet to perform their obligation is called executory contract. In a contract, one party has performed his obligation and other person is yet to perform his obligation is called unilateral contract. In a contract where both the parties have performed their obligation, bilateral and executory are same and are interchangeable. So now there here is topic disc offer. So, what is the meaning of offer? According to section 2, subsection A, when a person made a proposal when he signifies to another his willingness to do or to abstain from doing something is called offer. Here, the types of offer: express offer, implied offer, other is specific offer, just general offer, cross offer, counter offer, and standing offer. So, here are the explanation. Express offer: when offer is given to another person either in writing or in oral. When offer is given to another person neither in writing nor in oral is called implied offer. When offer is given to a specific person is called a specific offer. When offer is given to entire world at a large is called general offer. When both the person are making identical offer to each other in ignorance of others offer is called cross offer. Counter offer: when both the person are making offer to each other which are not identical in ignorance to others offer is called counter offer. Standing offer: an offer which is remain continuously enforceable for a certain period of time is called standing offer. Now, there are some legal rules for offer. Offer must be given an intention to create a legal relationship. Just a case, Bulfer versus Bulfer. Offer must be definite. Other one is there is a clear-cut difference between offer, invitation to offer, and invitation to sale. Other one is offer must be communicated. Mere statement of price is not an offer. So there is a legal rules of offer. Now, here the topic is acceptance. What is the general meaning of acceptance? According to section 2, subsection B, when a person made a proposal to another to whom proposal is made, a proposal is ascertained thereto. It is called acceptance. There are some legal rules for acceptance. First one is acceptance must be given as per the mode prescribed by the offerer. Acceptance must be given before the lapse of time or within reasonable time. Acceptance must be unconditional. Acceptance may be given by any person in case of general offer. Acceptance may be given by any specific person in case of a specific offer. Acceptance must be communicated. Other one is mental acceptance is no acceptance, or acceptance must not be derived from the silence. Acceptance must not be precedent to offer. These are the general rules of for acceptance. Now come to the point consideration. What is the meaning of consideration? According to section 2, subsection D, consideration is defined as when at the desire of the promisor or promisee or any other person has done or abstained from doing, does or abstain from doing, or promises to do or to abstain from doing something. Such an act or promise is called consideration for the promise. As also we say, when a party to an agreement promise to do something, he must get something in return. This something is defined as consideration. There are some legal rules as to consideration. It must move at the desire of the promisor. Case Durga Prasad versus Baldio. It may move by the promisee. Chinaya versus Ramaya. It must be past, present, or future. It need not be adequate. It must be real. It must not be illegal, immoral, or opposed to public policy. There are the legal rules as to consideration. Now, some points are discussed. Stranger to contract. What is the meaning of stranger to contract? It is a general rule of contract that only parties to contract can sue and be sued on the contract. This rule is known as doctrine of privity, that is relationship between the parties to contract. Some exceptions are over there. A trust or a charge, marriage settlement, partition or other family arrangements, estoppel, assignments of contract, contract with agent, convenience running with lands. There are the exceptions for stranger to contract. Now, what is exactly as we say, contract without consideration is void. Love and affection, there are some aspects: love and affection, compensation for voluntary service, promise to pay a time bar debt, completed gift, agency, section 185, charity, contract of bailment, section 148. So no consideration means no contract. Abdul Aziz versus Masoom Ali case. Kedarnath versus Gauri Muhammad. There are the details of consideration. Now, what is the meaning of capacity to contract? Capacity to contract is generally known as some following are the condition for a person to enter into contract. There are some following condition. When the person enter into the contract, he belongs to the capacity to contract. Like he must be major, he must be sound mind, he must not be disqualified by any other law. There are the aspects of enter into the contract. Now, there are disqualified person who is not enter into the contract, who is enter into the contract, minor, unsound mind person, and others ones. Who is the other one? Like that is alien enemy, insolvent, convict, company, corporation against MOA or AOA. What is the meaning of minor? Generally, as we say, according to Indian Majority Act, Section 3, minor is defined as any person under the age of 18 years. In the following cases, a person is said to be minor if he does not complete the age of 21 years. Like any person under the Guardian and Ward Act 1890, any person which comes under superintendence of law and legal representatives. There are the rules governing minor agreements. Rule 1. Judges are counselor, jury is the servant, law is the guardian. Rule 2. In case minor enter into a contract which is unlawful, illegal, immoral, he is also prosecutable and punishable under the relevant rule. So, what is the meaning of unsound mind person? According to section 12, a person generally sound, occasionally unsound, can enter into contract when he is of sound mind. A person generally unsound, occasionally sound, can enter into contract when he is sound mind. Person of unsound mind. Who is the person of unsound mind? First one is lunatic, idiots, drunken, or intoxicated persons. Now, there is a free consent. What is the meaning of free consent? Generally, according to Section 10 of the Indian Contract Act, one of the essential of a valid contract is free consent. Free consent is an essential element of the valid contract. So, according to Section 13, define consent as two or more persons are said to consent when they are agree upon the same thing in the same sense. According to Section 14, consent is said to be free when it is caused by coercion, undue influences, fraud, misrepresentation, mistakes. Now, what is the meaning of coercion? According to section 15, coercion means committing or threaten to commit any act forbidden by Indian Penal Code 1860 or unlawful detaining or threatening to detaining any other person, property with a view to enter into an agreement. It is immaterial whether the IPC is or is not in force where the coercion is employed. The threat amounting to coercion need not to necessarily be from a party to contract. It may also proceed from a stranger to contract. So, as we say, consent is said to be caused by coercion when obtained by the committing or threatening to commit any act forbidden by the Indian Penal Code, the unlawful detaining or threatening to detain any property. It is not important where the IPC or in force where the coercion is taking place. For example, A and B, both Indians are on voyage trip to America. When the ship is on the Atlantic Ocean, B threatens that if does not transfer his property to B's name, then he will push him into the water. Now, though the IPC is not in force on the Atlantic Ocean, it is still consideration as coercion. Thank you so much. Please keep watching and do like share. Thank you.